Hi, everybody. I'm just going to give it one more second to let people keep coming into the webinar. So if you just hold tight, we'll be back with you in a second. Okay, looks like we can start, ladies. Hi, everybody. I'm Andrea Krupp, and I'm the Director for Estate and Planned Giving at Providence College. I am joined again by my favorite women. Barbara Bolello is partner at Regent Atlantic. Kathy Entwistle is Managing Director with Morgan Stanley Entwistle Partners. And Maggie Jondro is Managing Partner at Jondro Wealth Management. Thank you, ladies, for doing this again tonight. It's our final session in our 3-session series of Money Matters this year. I'm so thrilled. I think you're fantastic, and this has been really fun. Tonight, we're going to talk about philanthropic giving and estate planning. We're going to start with the estate planning piece and then talk about how that ties in to your decisions about philanthropy and why both are important, and the elements you need to think about and how you get there. So I'm going to start off with the estate planning piece. I am a lawyer by training. I currently don't practice in the traditional sense in my job. I now advise people who want to use their estate plans and other vehicles to leave money to Providence College. But part of what I was trained to do is to think strategically, and that's the discussion that we're having. So I'm going to throw out a question that you guys aren't going to be able to actually answer, but maybe the panelists know this. So do you guys know what Sonny Bono and Aretha Franklin have in common, besides the fact that they were both in music? Anyone? Neither one.
Had a
Go
will?
ahead, go guess.
They
What
didn't
was
have a
it?
will?
They didn't have a will. And so you're right. Woohoo! So why does that even matter, right? It's kind of a cool fact that you'd think these people would have estate plans or wills. And, I think that neither one of them would have made that decision if they knew the fallout of not having a will or a trust or any kind of plan, because both of those people's personal lives were thrown into the public eye. Their wealth and their assets were contested. It got kind of ugly, and it lasted for many, many, many years because there were people vying for the right to property and money. All of that could have been avoided, and these people didn't have, they had the resources to talk to financial advisors and talk to estate planning attorneys, right? So we don't want anybody to be an Aretha Franklin or a Sonny Bono in that sense. So let's talk about the word estate, because people think, I don't need an estate plan. I have, a modest job. I have a modest house. I don't earn a ton of money, or I have enough to live and I'm comfortable, but I'm not wealthy. I don't have an estate. Yes, you do. Everybody has an estate. The legal definition for an estate, when you talk about probate, is any asset that you hold in your own name. So Barbara has a bank account in her name only. That's her estate. Kathleen has a car in her name only. That's part of her estate. Now Maggie has a house held jointly with her husband. That piece of property is not in her estate, in her own estate, because she has a partner that owns that jointly with her. However, when you die, the things that you own need to go somewhere. And if you haven't provided a roadmap or directions as to where that property goes, do you know what happens? The state in which you live has a series of statutes, and they lay out very specifically where that asset goes. And it may not jive with the way you would have done it if somebody had said, hey, did you know that your long lost cousin that you have never spoken to could get ownership of your house because that's the only living relative left, or however it works, right? Or that sister-in-law you cannot stand, she's going to be, driving around in that brand new car. There's nothing to be afraid of with the term estate. It just means property that you have in your own name. And in fact, the thing you should be afraid of is not being the one in charge of telling the rest of the world who gets your hard-earned assets. So there are common elements to an estate plan. A will is a document that can be very, very simple. And frankly, I think anybody who is of legal age and has a bank account even should start with a very simple will. Doesn't necessarily mean doesn't have to cost a lot of money, but it should be drafted by a lawyer. Probably stuff you do online, might be legal, but you don't have any backup and you don't have any expertise. Go to a lawyer. Very simple will, but you have an estate. If you have a bank account, you have a car, you've got an estate. And as you get older and as you gain more assets, you might need a more complicated set of directions, right? A more complicated will. You start having children. Who's going to take care of those children? That is an element of the will. You would name guardians for children who are underage. You name an executor, somebody who, when you die, will take your will, take it to the attorney and take it to probate court and say, I promise to follow the instructions that are laid out in this will. I will give the car to Aunt Sally. I will give the house to the children. I will do whatever is set forth here. It's a roadmap. Now, with a will, it's a public document. Once you die, that document is filed in probate court, which is usually the clerk's office of the town hall in the city in which you die. So you might your house might be in Providence, Rhode Island, but you were in a nursing home in East Greenwich and you died there. The probate court would be in the East Greenwich town hall, okay? I could walk in and say, hey, I know that Sonny Bono died and he was in East Greenwich and he had a will. Can I look at what was in that will? And I can pull it up and look at everything that he laid out. It's public. The other document that you can use as a roadmap is called a trust. Now, you have heard about trusts, and in a lot of cases, the way you hear about it is because very famous people, very wealthy people will create trusts. There are revocable trusts, which means throughout your life, you can make decisions to take things out of the trust and put things in. You can change your mind. Or there are, I said that right? Did I say revocable, right? Okay. And then there are irrevocable trusts, which means as soon as you put something into the trust, it's there. It's owned by the trust. Think about the trust as almost your shadow. It is not you. It is something that looks like you, and you have told it what to do, but it is a separate entity. It is a legal entity on its own, not like a will. Will is different, all right? So a trust owns the property you put into it. If you put a house into a trust, the ownership on the house is going to say the trust of Andrea Krupp, okay? And I can be the trustee. I can control the things that are in the trust, but they are not owned by me personally. Now, there are lots of benefits to that. I'm not going to go into all of that too much, but the difference between a will and a trust in a really practical way is that a trust is not a public document. It does not get filed in probate. It is a private document that your attorney keeps, and your trustee is the person who, the equivalent of the executor in the will. The trustee is the person who says, here's what the instructions are and here's what I'm going to do with them. Okay. And for a lot of people, that's important. That privacy element is very important. Another component of an estate plan, a good, solid estate plan, is a financial power of attorney. Financial power of attorney is very, very powerful. It is effective as soon as you sign it. I might say, okay, Maggie, you're my best friend. I trust you. I'm going to give you financial power of attorney. That means that Maggie has access to all of my bank accounts, anything that I hold in my name financially, so that she can access it. And the idea is she can access my finances if I cannot access them. The situation here is typically a stroke. A person has a stroke, they haven't died. They might even be conscious, but they don't have the capacity to make a decision or to sign a check or to authorize payment on a mortgage. Maggie can do that for me. She has the authority. Now, you have to be really, really careful, because as soon as I sign that, whether or not I am of capacity, whether or not I am in a coma, unable to speak or not, Maggie can go to the bank and take that money and act on my behalf. I've given her that power. So that trust must be there. You have to be really careful when you do that, but it's an important document. The other document that is a power of attorney is a healthcare power of attorney. Now, this one is not, it is not valid until you are unable to make a decision for yourself, until you are in a coma, until you are, unable to communicate or speak for yourself, if you are incompetent, mentally incompetent for some reason. Then your durable power of attorney for healthcare kicks in. And it is a document, the ones that I like are pretty in depth. The one I used to give my clients were really 10 pages long. And they asked things like, do you have a priest? Do you want to be visited by a priest in a hospital? What's their name and number? Who do I call? Do you want to be fed through a feeding tube if your chance of living will be extended? Very personal, intense questions, but very, very important. And they're important for you because they give you an opportunity to think about what it is you might like to have happen. The version I like really does talk about, okay, if this, then this, but what about if this happens, right? There are some really watered down versions that just say, do you want a feeding tube? Well, okay, you might off the cuff say yes or no, but you haven't really thought through okay, well, maybe I do, or, what if another situation comes in? So I guess I'm just saying, don't necessarily automatically go for a short and quick form. Take some time, look around, see what your options are, because again, it's a roadmap. It's a roadmap for the people who love you and who want to do what you ask them to do, right? It takes the pressure off. They don't have to make decisions the more you have told them what those decisions would be, if you could speak for yourself. The healthcare power of attorney is actually a statutory document. Rhode Island has one on the Secretary of State website. Their version is actually one I used to like. I haven't been on recently, but it's something you can download. I never charged for doing that when I was an attorney, but it's always something that a estate planning attorney will put into your packet and say, this is an important piece. So that would be a complete estate plan. Now, the other piece of this is that you have an estate planning attorney, and that estate planning attorney needs to be in contact with your financial advisors, right? As you're going forward, you're going to want to know that, if I say I'm giving my house to so-and-so, does that make sense with my financial plan, right? Am I going to have a house to give to so-and-so? Is that part of my long-term vision? All of these professionals that you work with need to be in contact with each other, and you need to communicate with your family members. Not necessarily the nitty-gritty. You don't need to tell them you have, $1 million set aside or whatever that is, but you need to tell them you have these documents in place. Where can they find the documents? The healthcare power of attorney should have given consent to be a healthcare power of attorney, it's not necessary that your oldest is the one you choose. That might not be the right person to make a healthcare decision, right? Your oldest may hate the sight of blood, not want to go anywhere near a medical decision. They're just not going to handle it. But they might be the one to handle the financial pieces of your estate plan and work closely with your financial planners to make sure that gets done. So picking the people to be the executor or the trustee is also something that takes time, and having a professional walk you through is worth everything. It really is. A part of the estate plan that a lot of people forget about is the philanthropic piece. So after you have looked at what you want to do for your family, how do I want to care for the ones I love? What do you do during your life to give to other people, right? If you're the person who goes to church every Sunday and you are giving every Sunday, and then you give to the annual appeal, and you know that's important to you, one of the things to consider is whether after your death you want to give a gift that keeps on giving even though you are not here. That's another piece you talk to your financial planner about, and you talk to your family about, and you also talk to the charity or the organization that you are going to leave money to, so that you can make sure when it's done, the language you've included in your estate plan makes sense, that you use the right name for an institution, that kind of thing. It's about communication. So let's shift from the nuts and bolts of what estate planning is into the planned giving and philanthropic pieces of an estate plan. Kathy, you have a great way of communicating in your family about, in a tradition of talking about philanthropy. Why don't you start us off with telling people how you guys do it, how it works for you, and then we can go from there.
Great. Thank you for having me. I have to apologize. I feel like I'm in the dark. I'm going to figure that out in a few minutes. I am at a friend's house and not sure how to get the lights back on. So apologize for that. But you always have to plan. You never, man plans, God laughs, right? But one quick thing, I noticed Brenda had a question. She's leaving at 6:30. She said, I don't know if we can answer her question, then I'd be very happy to jump in. But Andrea, with your background as an attorney, I think you could answer fairly quickly.
Hold on now. I had to unmute myself. All right. So Brenda says she has a revocable trust. Can I write a codicil to make changes or add items until I can speak with my attorney? So Brenda, you need to speak to the attorney in order to add things to the trust. So you're writing something on your own. If I'm understanding your question correctly, you can't do something on your own to change your trust. That needs to go through the attorney. But if it's a revocable trust, it can certainly be, you can add things to it and change that language very, very easily. But you can't do it on your own. All right. There are special rules that need to get followed, and ways things get signed and who witnesses it, that kind of thing. All right.
Thank you, Andrea.
Thanks.
Okay. So what I was going to speak about for a few minutes was giving and different ways we can give, and how important it is to have conversations around our family values with our family members. And giving is a great way to establish those values and goals with your children, your parents, your siblings, whatever it may be. So every year, our family around Thanksgiving, I think this was the story that you like, Andrea, we meet and sit down, and we all come to the meeting with one charity that we would like to give to, that's important to us, and why. And you almost have to do a presentation to the family. Now, there's 6 of us now in the family, because my son's wife is now doing this with us as well. And if all 6 are great charities, we'll give a gift to all 6. but you basically come and you say, this is the charity I love, this is why. And I will tell you, as a parent with 3 adult children and now a daughter-in-law, I'm amazed at what's important to our family members. And it's such a great way to have a conversation around giving and philanthropy and also family values. I would highly encourage you to do that as well. This can be something very small. It could be, $100 each, and you each get $100 to give to a charity. We established a donor advised fund for our family a few years ago. And the reason why we did that, we thought it would be a great option to put funding away for giving to causes that are important to us. And there are some benefits to doing it this way. And I thought I could run through that fairly quickly. So a donor advised fund, one of the benefits is you can gift money, appreciated stock, directly to the charity. You get the deduction immediately. I am not a tax advisor. I always defer to the CPA for the tax advice piece, but it's an incredibly valuable way to get some tax deductions personally. And then when you put that in, if you give appreciated stock as opposed to cash, instead of selling stock that's appreciated and paying taxes on the sale of the gains, the capital gains, instead you donate the entire stock. You do not pay any taxes on it. It goes into the donor advised fund, and then the donor advised fund can sell it there, or they can invest according to an investment plan within their donor advised fund, so that money can continue to grow. You do not have to give it all away at that moment. Sometimes you want time to think about where you want to donate money. You get the tax deduction immediately, but then you have this tool that you can use to gift money over time to different charities of your choice. So it is something that can be a legacy item as well for your family. So those are some of the things that, we've used for not just our own personal family, but for our clients as well. And it's very valuable. Talking about money can be hard. People don't know where to start. And sometimes talking about giving first is a great way to spark a conversation. Andrea, did I leave anything out, or any of the other women on the panel? Did I leave anything out that you want to jump into and share?
No, I think that so donor advised funds are things that you create with a bank. Do you have it? Is yours with a bank or a?
So at Morgan Stanley, Fidelity, there's plenty of companies out there where you can let them know you'd like to establish a donor advised fund. There's typically a minimum amount that you need to establish. What's nice, it's usually very affordable. It could be $5,000, it can be $25,000. That seems to be the average range of what I see to start a donor advised fund. And you don't have to maintain that dollar amount. You just have to start with that dollar amount. Sometimes the gifts that you give have to have a certain minimum gift. So sometimes it's $100, sometimes it's $250. So if you give lots of small donations, it might not be the right fit. But if you give gifts of at least $250 or more, it could be really, really nice. And then in terms of just, you can name it whatever you want. And you have to make sure that you give to an accepted 501c3. So you have, which is a charitable organization. And you have to be sure to get that, approval in advance, because they can turn you down if you want to donate to something that is not an approved charity.
If I could also interject, a big piece of donor advised funds that's important is it allows you to maximize your given tax deduction in 1 year. So if if you plan on giving Providence College $1,000 every year for the next 10 years, obviously giving $1,000 is not likely going to move the needle on your taxes year to year. But if you say, okay, what if I lumped that, put $10,000 into a donor advised fund, then you get to take the $10,000 deduction that year and then continue to give your $1,000 to Providence College over the course of 10 years. So the taxable piece is really sometimes a big motivator, I think.
And I just want to clarify. So I'm not a tax person either. I went to law school, so I didn't have to look at numbers and look where I am now. But when we're talking about these tax benefits, they may or may not apply to you. You need to have your conversation with your CPA, your accountant, because you might not, you might not itemize. It might be, you might give up to the standard deduction and be done with it. So these are all possible benefits for you, but not guaranteed. So don't go and, Andrea Krupp said, because I'm putting in my disclaimer. The only other piece I want to say is with donor advised funds, a lot of people call them their charitable checkbook. Some folks actually used to give out checkbooks. I know the Community Foundation in Rhode Island used to have something like a checkbook, and you would have $10,000 in your donor advised fund. And you could write a check and give it to, Providence College, and that was a gift. It was a legal tender. Others do it online. You go online and you just say, send, X amount of money to this charity. And as long as it's a charity that is a 501c3 and approved, that money just goes really quickly. It's very simple. The donor advised part is that you are advising where you want the money to go, but the entity that holds that money does have the right to come back to you and say, I'm sorry, I know you think that, that shelter down the street is a great cause, but they haven't filed the right paperwork. They don't have the right charitable status. Let's find another one that does. So that's the part, is you advising where you want it to go, but they're not tied to giving it to that specific place.
It's very unusual for something that not to be approved. As long as it's a 501c3, it's very unusual for something not to be approved.
So, Barbara, can you just talk a little bit about a foundation, right? So donor advised fund, what's the difference between starting your own foundation?
So I would say the major difference between a donor advised fund and a foundation is effort. The donor advised fund can be established on, as Kathleen said, a variety of different platforms, whether it be Fidelity, Charles Schwab, etc. They can be set up rather cleanly and quickly. The transactions are done online. There's no need to consult with an attorney. You basically just set up the entity yourself online. The charitable checkbook is also a huge benefit, and again, ease of use. And who at this point in their life does not want to hit the easy button? I know that I do. So on the other side of that is a charitable foundation. And that's where things get a little bit more complicated. Another sort of distinction is cost. The cost to set up a foundation, really all it is approaching your estate attorney to go ahead and create a legal document. That legal document will also require a legal tax identification number. So there are reporting requirements from a tax reporting perspective as well. So cost in setting up, costs in doing the tax reporting every year. Those can be, costs that can be avoided. Foundations are generally used when you talk about really having sort of an upper echelon level of wealth that, with the sort of, I think the circles that we're all traveling in are not sort of the, not the Silicon Valley of old. But I do think that foundations can be a good way of doing things. But I think you're sort of going into, you're lighting a fire with a blowtorch versus a match. You don't really need to sort of pull out a foundation, create a foundation, be responsible for the cost, be responsible for the reporting, when a donor advised fund is really effective and very productive as well. We use donor advised funds a lot, as Kathleen said, because they're easy to use. And it's also a great opportunity to talk about charity and I have my own kids, how to think about charity as you're growing up. So it's a great way to educate your own children to say, got a lot of good things in our family. It's also time for you to give back. And it allows them to see online, right, through a Fidelity platform, for example, what it means to go ahead and select in the whole process. So again, I think you can accomplish what you need to accomplish with a donor advised fund.
That's quite all right.
My dogs love this topic, so they get very excited. You don't really need to use a foundation, again, unless you're specifically advised by your tax person, your wealth advisor, or your attorney. If anyone wants to talk more about that, we're happy to. But again, I think a donor advised fund can be very, very productive, cost efficient, and effective, especially when it comes to educating next generation.
Maggie, so before we get into your topic, and I want to talk, Maggie's going to talk about split interest gifts. So gifts that pay you money during your lifetime, and then at least one of them or two of them is going to do that. And sometimes, anyway, she's going to talk about that. But before we do that, one thing I do want to say is that endowment funds are also another way that you can create a legacy for your family to continue giving to. So for example, and I'm using Providence College because that's where I work. So you can translate this to your personal life if it's a little different. But at Providence College, you might want to create a scholarship for students who are female, and or students who come from a certain region, or just students at Providence College. That creating an endowment fund takes the gift that you were going to give. So let's say you're going to give $50,000, which is the minimum at Providence to start an endowment. Instead of giving $50,000 outright and just saying, here you go, use it for scholarship, use it to give kids some money. That gift of $50,000 can get spent down to zero, right? If you just give it that way, give it outright, the college will spend it. Kids need money, right? If you put it in an endowment fund, that $50,000 is kept, it's called the corpus, it's the main gift that is kept untouched and invested over a series of 12 quarters before it starts to distribute a percentage every year. And as your gift grows, you can continue to give to it. Every year you can give a little bit, you can give a lot, you can have family members give to it. That grows and the percentage stays the same, but you're giving 4.5% of whatever the market value is, right? We have a formula that we determine, and that never goes away. So you put it in your family name, you put it in your name, you put it in honor of a professor, and we have lots of people who've done that. That is part of now the history and the foundation of the charity. So that's a great way to talk about legacy and to communicate to the organization that you're with how much you appreciate them. It gives that organization the opportunity to say thank you and to show you the impact that you're having. You can meet students, you can see the building going up. So it's something that you can do during your lifetime. You can also create one from an estate gift. So you can say, I'd love to do this, I just don't have the cash right now, but when I die, there will be assets that are liquidated, my children will be taken care of, and I'd like you to take a portion of that and create an endowment fund. You won't be there to see that immediate impact, but your family will, and you will still now become part of that legacy of people who have done this. Yeah, so that's just another piece. Maggie, talking about a lot of things where you're giving money away, and there may be opportunities. I know there are opportunities where your gift can still pay you some income, and you can craft things that are a little bit different. So why don't you give us, I'm thinking specifically charitable trusts, and also, if you're comfortable, charitable gift annuities. If not, I can take that piece.
Sure. I saw two questions, but it looks like they were answered. Great. All right, so I just have a couple slides that I had already had together. So I figured I'm a visual person, so I decided to include them. So generally speaking, trust in general, they're gifts to charity in which the donor, meaning anyone who's giving, retains a partial interest in the money, right? And so these trusts offer donors conduits for charitable giving while still maintaining some sort of interest in the trust principle. And they can be established during the donor's lifetime or at the donor's death. And there's two basic types of charitable trusts: a charitable remainder trust and a charitable lead trust. So if I start with a charitable, remainder trust, they allow for the donor to receive income for the trust for their lifetime, the lifetime of another person, or a period up to 20 years. At the end of that specific time, the 20 years or the specific lifetime, the remaining trust assets are distributed to a charity, the charitable remainder beneficiary. And there's, so again, just to keep it simple, you get to still use the money during your lifetime, for example, and then when you pass away, it can go to your named charity. And there's two types of charitable remainder trusts: a charitable remainder annuity trust, or a CRAT, and a charitable remainder, annuity trust, and a charitable remainder unitrust, a CRUT. The names aren't very cute, I must admit. So to keep it high level, a charitable remainder annuity trust will distribute a fixed amount each year, while a charitable remainder unitrust distributes a fixed percentage each year. So let's say you have investments in your trust, they may fluctuate every year. And so if you know you want to just give 10% every year, perhaps this the CRUT, which may have securities in it or investments in it, might make sense, because let's say there's a recession, then you give a little bit less. And when there's a really great market, you might give more. One thing that's really important to note is that additional contributions may not be made to charitable remainder annuity trusts, but they can be made to charitable remainder unit trusts. I'm not going to go into the taxation too much. As already, the disclaimer is here that we are financial advisors. We work very closely on these topics, but I highly suggest looping in your full team: financial advisor, your estate planning attorney, and your accountant, your CPA. And the person that's going to write the trust is your estate planning attorney. The thing I also encourage you to is not to write a trust and then never loop in your financial advisor. Thankfully, I have not seen that, but I've had estate planning attorneys tell me that those documents, their client never brought it to their advisor, and all of their accounts were not correctly titled on their advisor's side. So it's really important you have the team working together.
And one thing, Maggie,
yes.
just when you're creating one of these trusts, there is a 10% rule. So yes. So when you're, you have to have enough money to create a trust, so that based on your lifetime and the amount of money you've put in, 10% will be going to the charity. And the programs that we use to create these and run numbers will tell us that when we put in a number and say, okay, it's $1 million and he's 70 and they want 2 lives and they want an annuity trust, based on those ages and the amounts, that might not be possible because it won't have enough money to fund that 10%. So it is a calculation that you do need an expert to have work with you on.
Absolutely, absolutely. This stuff is complex, but it might be right for you, which is why it's such an important conversation. And this particular charitable remainder trust particularly might be attractive to you if you wish to realize the immediate tax benefit of making a charitable donation, but also have a need for an income stream. So I'll kind of pause there for now as to not make it too complex. But to summarize, again, this will have a distribution every year. And then once that period of time or that lifetime is over, the remainder goes to charity. Charitable lead trust, or CLTs, are basically the opposite. This pays trust income to a charitable beneficiary. So it's first going to charity for a specific term, and then it distributes the remaining assets to a non-charitable remainder beneficiary. So this could either be the grantor or it could be their heirs. So again, let's say that you want to be charitable, you have a pot of money that you do wish to give over the course of your lifetime, but you also want to make sure there's something left for your kids or grandkids. This could be a really good tool for you. And what's kind of beautiful about this, much like the donor advised fund, you get to see your charitable dollars at work during your lifetime. There's also two types of charitable lead trusts, and each satisfies a particular planning need while providing certain tax benefits to suit your specific situation. So a non-revisionary lead trust names someone other than the grantor as the remainder beneficiary, and there is no federal income tax deduction upon its creation. The trust itself, however, will receive an income tax deduction for the income payments made to charity. Again, I'm not going to go fully into the tax piece here because, again, you should really speak to a professional, but just know that. A grantor-led trust, on the other hand, reverts to the grantor or their spouse as the remainder beneficiary and qualifies for an immediate income tax deduction based on the present value of the annuity or unit trust payments to the charitable institution. So this type of charitable lead trust may be appealing if you need an immediate charitable deduction, but want to also retain control of the gifted assets. One thing that I also kind of want to make mention is there are some income limitations or how much you can put into trust too. So first, gifts, as already mentioned, have to be made to a qualified organization, such as designated by the IRS. So we sort of talked about this. And the deduction that you get is also limited to a percentage of your adjusted gross income. So the maximum deduction, and again, check with the professional as things can change every year, is 60% of your adjusted gross income for a cash donation, 50% of your adjusted gross income for other properties. And then contributions of long-term capital gain property are also capped at 30% if the property is given to a 50% organization. So it's really important to remember these things. And also if you're gifting long-term appreciated stock, I believe there's another cap on that as well that I can't remember off the top of my head right now. Andrea, anything to add? I know that you're the estate expert here, so.
No, I think they're great. Just I've been working actually on a couple of charitable remainder trusts with some donors, and they really can be a wonderful way to make a gift. There's some benefits to that don't exist for other types of gifting vehicles. So just keep that in your quiver of things that you might want to consider, and talk to your professional about it, because it might be the perfect tool for you. It might not, but it's always good to at least ask the question.
Absolutely. And a last piece I wanted to also share with everyone is, I think, a common theme for all of us through this conversation was the importance of communication. whether that be communication with your professionals. To give a very quick example, because it just happened this morning, I had a client whose mother, who was in her 90s, just passed away. And she did have a very simple trust created, the mother did. And it was done a very long time ago. So it's still valid, but it's not quite up to the standards that we would do today. One thing that was missing is a will. And you know, in the professionals and the estate planning professionals that I speak to, they say it's really uncommon for there to be a trust and not a will. So that just gives you perspective how long ago this was done. So first thing is you want to be updating your estate planning documents every 5 to 7 years, or anytime there's a big life event. Someone new being born, a divorce, a death, a move, because there's different state estate planning laws as well. The second thing is you want to make sure your professionals know about each other. And at the very least, at some point during your lifetime, you've introduced them. So something I do in my practice is I ask all of our clients, do you have a will, power of attorney, medical directive, and trust? And who wrote that? Give us their name. And please connect us if you so choose, but at least I have their name. And same thing with an accountant. Because again, in this example, these professionals are not speaking to each other. And, you know, she's coming to me as her advisor saying, you know, my mom's advisor is passing the buck to the CPA, and the CPA is passing the buck to the estate planning attorney. And why aren't we all talking the way you've talked with my professionals? So if they're not encouraging you to do that, if your professionals aren't encouraging you to do that, bring it up with them and make sure you have that open communication. And if you're comfortable, I would encourage to have your kids or whoever you're leaving the estate to involved in the conversation as well. And I think that's the second theme that's really run through this program, which is open communication with your family. And that doesn't mean that you need to tell them everything that you have or dollar amounts, but at least introduce them to your professionals so they know who to turn to when you do pass away. Remember, this is going to be a really trying time for your family, a really difficult time. And the last thing you want to do is leave them with trying to figure out where to go. So one thing we developed, and I'm happy to share with anyone on this call, just email the team and I'll send this to you, is we developed a family legacy letter. And again, there are things like this online you can purchase. Maybe your own professionals have something like this. But as it says, it's a personal inventory booklet. And you can write a little letter here to your loved ones. And when you have that family conversation, well, maybe all you have to do is share that letter with them. You don't have to share all the contents in here, but they know, our clients who use this, know their kids or whoever their beneficiaries are, know, all right, we got to call Jandra Wealth Management. If anything were to happen, they have the golden Bible, so to speak. And you can see the contents include personal information, contacts, personal, professional, location of important documents. So again, is there a safe deposit box? Where's the will? Where is our birth certificate? The whole financial picture, your insurances and other miscellaneous things. It even includes passwords to your accounts, because again, back in the day, we weren't online. And so you could sit by your deceased parent's mailbox and at least eventually you're going to assume that all the bank account statements will come through. Most people are paperless now, and you might not know something exists if it wasn't put into something comprehensive like this. So again, I'll kind of stop there and turn it over to all of my colleagues here, but conversations are really important to have, especially with these complex situations.
Maggie, I love that. I think that the same way that I really think a detailed health directive is a gift to someone, I think a detailed document like that is also a gift because it takes pressure off, right? And it's more work for you, but you are the one who holds the key to all of this. It's your decision. This is all your gift to other people of assets and information that belongs to you. So you don't have any obligation hear me, you don't have any obligation to give money to your children. You don't have any obligation to give money to your sister, your brother-in-law. This is what you want to do and who you want to pass things on to. And it doesn't mean you don't love them if you don't give them money. You want to give it to somebody else who you think needs it more, or for whatever reason. You don't need to share any of that. But if you don't take that power and that decision making now, then you've just lost a little bit of that autonomy, right? And what you've worked so hard for and the values that you hold, they get lost. They get a little bit diluted if people don't know about it. And I think the piece I also want to reiterate, just like a financial power of attorney is powerful as soon as you sign it, the document that Maggie has, it's not a legal document. It's not a powerful legal document that gives people the authority to, you know, get your bank accounts, but it has a lot of information in it. So where you keep that document is important. It's going to have your passwords, your bank account statements, all of that information needs to live in a secure place. Whether you have a safe in your house, you have a safe deposit box. I always kept, we offered our clients when I was practicing, they could keep the original will or trust or estate planning documents in our safe. And we gave them a copy that said the original lives at X, Y, and Z law firm. You can do something like that where you keep a redacted version or a watered down version or the front page in your house, and you give that to someone and say the original lives, you know, with my financial planner or my estate planning attorney. But just be careful, right?
I was gonna say online, no, a Google Drive is not a smart place to do it. Speak to your professionals. Maybe they have something online. I know that we encourage our clients to send their documents to us because we have a very secure portal that they can keep it in. But be very careful, especially with online.
So I think that we've given you a lot tonight. I think all of us could continue this conversation for another hour, but we're not going to. We're going to let you, relax and enjoy the rest of your evening. I don't see any more questions. So take a minute. If you do have a question, type it in now. Feel free. And really, thank you so much for coming. This was, let's see. Oh, thank you, Miriam. Miriam said outstanding. This was our first attempt at a session for women. We are all, really feel very strongly about empowering women and giving information and having safe spaces to have conversations like this. We're all available to you. And please feel free to reach out to us if you have questions after this. We hope that you join us for More Money Matters next year as we do another session. We do have one session in February, but it's geared toward students, seniors in college, and students who are graduates about 10 years out, between that young professional group, because we'll talk about all the things we did over the course of these 3 sessions. We'll give them a little taste of it in one fell swoop. So if you know anyone, you have a daughter, a granddaughter, or anyone at all who you think might be interested, please have them sign up. And again, we're happy that you are here with us. Thank you so much. God bless you all, and make smart choices. All right. Bye, guys.